All right. We'll call to order the meeting of the House Judiciary Committee. Representative Scoggins, if you'll open us up in an invocation.
May I please? Is it on? Okay. Okay, bow your heads, please. Most kind and gracious Heavenly Father, thank you for the opportunity to be here and serve the state of Georgia. Thank you for all your grace and mercy that we see you give us each and every day. Please be with us in all of the decisions that we make and lead us and guide us as we travel to and from here every day. In God's name I pray. Amen.
Thank you, Senate Majority Whip Randy Robertson. You have two bills. Come on up and tell us about your bills. I want everybody to know Chairman Stan Gunner is alive and well. He is up on the third floor in the Special Rules Committee on Tort Reform. And Chairman Wendell Willard, who is now living in Aiken, South Carolina, says hello to everybody. And I'll let you pick the order of the bills.
Thank you, Mr. Chairman. And I do want to say I'm going to line this stuff up real quick. I just ran from House Rules where we had an abundance, Senate Rules where we had an abundance of House bills that we were able to get through. And I think we ended up getting about 6 or 8 on the floor tomorrow.
Thank you.
Well, I picked one from Chairman Crow. It's,
not.
right. Well, I would tell you, Representative Kelly, you did have a nice bill on there. But to be clear, it'll be on there again tomorrow. But yes, but you know where it's going. We're in good shape.
We've got 245 and 298. You pick which one to
I'm
start
sorry.
with. I'm sorry.
100.
100 and 298.
Yeah. If I could start with 100. I think that's the easier of the ones.
Absolutely.
And y'all have seen this piece of legislation before. You've seen it the last 2 years, and I've never been somebody that believes in chewing my cabbage twice. But I'm gonna tell you something. This is a piece of legislation that's very near and dear to my heart and the world that I live in. And when the Dobbs Act passed, out of the U.S. Supreme Court, I felt that we were all obligated to take care of children. We have fought for it for years and years and years, and I think it obligated us to fight for those children in the womb and those children outside the womb, whether they be foster children, adopted children, children lost and alone. I think it fell to those of us who cared about life to fight for it. And what this does is it gives adopted children the exact same right that biological children have. I have a son and daughter that are both well beyond the age of 18, but as biological children of mine, they can go and get a copy of their birth certificate anytime they want to. And I have a daughter who will be 6 years old next month, and she and other adopted children in Georgia do not have that right. If she goes to get her birth certificate at the age of 18, she's required to hire an attorney. She has to go to Superior Court, and she has to argue her case in court, and a Superior Court judge has to give her permission to get her original birth certificate. And I love my children equally and all the same. And I have a heart for the mothers and fathers in this state that go out and choose to adopt children who are placed up for adoption. And I feel that those children are no different than any other children, and I would appreciate any consideration in passing this bill out to the floor. So that we can hand all of the thousands and thousands of adopted children in the state of Georgia the right to go out and be treated equally to those biological children. And I know there's somebody here to testify, and I'll be happy to yield for any questions.
Thank you. Any questions for Majority Whip Robertson? All right. Thank you for your testimony.
Thank you.
All right. We have a number of people signed up. We have Jamie Weiss. Jamie Weiss. All right. Ms. Weiss.
Good afternoon. Thank you for having us here again to speak to you about this bill, and we appreciate all of the support that you have given to it in the past. This really is very simple. It only becomes complicated by the myths and misconceptions that exist. The biggest myth that is out there is that there was a promise of anonymity to birth parents, and that just is simply not true. It never existed because it wasn't ever legally possible, based on the laws and procedures in Georgia, and that's how we know this. One, there was no promise in the relinquishment papers that are signed by the birth parents. Two, by the process of how birth certificates are issued. And three, because a judge can unseal at any time, as Senator Robertson had mentioned. But I want to focus real quick on the relinquishment and on the process of the birth certificates. It's important for everyone to understand how the process of issuing birth certificates work, so that you understand that this promise was not legally possible to be given, or something that should try to be upheld by the state. When a person is born, the facts of their birth are recorded onto their birth certificate, and that birth certificate belongs to them. Just like each of you have your birth certificate, you can go get a copy of it. You don't need to go ask anyone's permission to receive it because it's yours. But if a relinquishment takes place, then those parents would sign relinquishment papers. And in those papers, there is no promise of anonymity. We have the standard form all the way from 1979 until currently has been the exact same form that parents sign to relinquish their rights. And it has not changed, and there is no promise in there. When they do sign away their parental rights, they sign away all of their parental rights, including any say that they would have over the child's birth certificate. Otherwise, relinquishment has no effect on the birth certificate. It still belongs to that person who was born. Only if an adoption takes place, which is not guaranteed, and if the adoptive parents request an amended birth certificate, only then is the original birth certificate sealed. And the intention behind that was not to seal it from the person it belongs to, only to keep it from public view because of past stigmas that existed. About
When it's sealed. Sorry.
So it's only sealed if an adoption is finalized, and if the adoptive parents request an amended to be issued. When the amended is issued, that is what triggers the original to be sealed. Relinquishment has nothing to do with sealing the birth certificate. And that's evidenced on the form that I have provided to you. It's the Certificate of Adoption Form 3927. You'll see on the back, I have circled where it indicates adoptive parents have the choice to check this box and ask that an amended not be prepared. And therefore, the original birth certificate, again, would still remain with the person whose birth is recorded on it. So you have that there so that you can take a look at that. So it's purely just about equal rights. When adopted adults, they're 18 and they wish to obtain their original birth certificate, we purely should be able to do that, the same as all other Georgians. And that's really what it comes down to. So we just ask that you guys, once again, favorably report this bill so that we can hopefully get it through the House this year and onto the governor's desk. So, and I'm happy to take any questions.
Thank you, Ms. Weiss. Any questions for members of the committee? All right, thank you. The next witness is Courtney Humbaugh.
Thank you.
Thank you, Jamie. Hello, sir. Hi there. Thank you so much for having us again this year. My name is Courtney Humbaugh. I'm a Georgia resident. I'm a Georgia-born adoptee, born in Augusta, Georgia, and adopted in Decatur, Georgia, and that's where I grew up. I wanted to share with you about experience I had in 2020. I decided to petition the state of Georgia, the Department of Human Services, for my original birth certificate. I wanted that piece of paper that told me the facts of my own birth, city that I was born in, hospital, and if I was really born on Christmas Day. That was the intent. So I paid an attorney thousands of dollars to petition the state, and after 6 months, I received my original birth certificate. Having to petition the courts by spending thousands of dollars and lots of time working with an attorney to receive what everyone else, probably a lot of you, can easily receive, is pretty discriminatory based on ability to pay. All other Georgia-born citizens pay a minimal fee. I believe it's about $40, and their original birth certificate is mailed to them. In addition, as Jamie noted, those relinquished and in foster care have their original birth certificate. So sealing of birth certificates is not based on relinquishment. This bill is solely based on giving the adult adopted segment of our population that basic human right to obtain their own document. It is a birth certificate about their own birth. So Alabama, for example, their adult adoptees have had this right for over 25 years with no reported issues there or in any of the other states that have restored this right to adult adoptees, or in the 2 states that never even sealed original birth certificates at all. So we just ask today that you please pass this ethically sound, common sense, equitable bill. Adult adopted persons throughout Georgia and organizations that are standing behind us throughout the U.S. are watching, and we hope that you can pass it today.
Thanks,
So,
Ms. Humble.
any questions?
Floor Leader Hall.
Thank you. And I'm not opposed to the bill. I just want to get to know understand the process a little bit better.
Yes.
You said it took about 6 months. Is that on average how long it takes?
I believe
once
so.
a motion's filed, and it's a petition to the
Now-
court.
It was in 2020.
Okay.
So I don't know if because of COVID and all the things going on Zoom, if that took a little bit longer. But
Okay.
typically, my attorney did say that it takes 4 to 6 months when we started the process.
Okay. Thank you.
Any other questions?
Any other questions? All right, thank you for testifying.
Thank you so much for your time.
All right, any other witnesses? Yes. Mrs. Robertson.
Hi, thanks. I didn't want to let the opportunity pass. My name is Teresa Garcia Robertson, and my daughter is Andy, who the bill is named for. She is hilarious, brilliant, and almost 6. I was in the room when her first mom brought her into the world, and I got the immense honor of cutting her umbilical cord. She is a delight and what makes my world go round. But I am fully aware that my life with Andy came at a great cost. At a cost to her first mother and her family, as well as to Andy in ways that she won't comprehend for years to come. Yes, I am grateful for the privilege of being Andy's mama, and yet I grieve for what should have been. A life with a woman whose heartbeat and voice will forever be the song of our daughter's subconscious. Andy knows that she is adopted, and we are at a stage where we are answering lots of questions about whose tummy she was in. We remind her that she grew in her first mama's tummy, and we provide a name and a photo to go with our explanation. But even if she did not have a name and a photo, that certificate with Andy's name on it, given to her at her birth, belongs to her and her alone. Not me, the mother raising her, and not the mother who gave birth to her. It belongs to Andy. If we are a state that truly values life, we will stop discriminating against the very people we have fought to give life to and allow them to be treated as equals under the law. Andy's dad and I could and would go through the process of getting an attorney to secure Andy's right to her original birth certificate when she turns 18. But my ask today is that you would grant Andy equal rights under the law to obtain her birth certificate the same way those born into the privilege of being raised by their biological parents are afforded. Thank you.
Thank you so much. Any questions? All right, anyone else on Senate Bill 100? All right, what's the will of the committee? We have a motion do pass and a second. Any discussion? Okay, no discussion. I will add that Jim Outman of Hester Outman sent an email to many members of the committee in favor of the bill, and I believe he testified previously on this, and I know that law firm to be a very prolific adoption law firm. All right, we have a motion, we have a second. Any deliberation? All right, all in favor, please say aye. Aye. All opposed? All right, the bill passes.
Thank you, Mr. Chairman.
Thank you. Tell us about Senate Bill 298.
Yes, sir. 298 is much simpler than 100, I promise you. I'm reading off LC 492325S SCS. As we all know, in this climate we're going through right now, there's many bills we hear that cross back and forth from the Senate to the House and the House to the Senate that deal with immunity processes of our municipalities and and county governments. And all this bill does here is offers a little balance in that process to when a claim is made against a jurisdiction that that whether it's for sovereign immunity, municipal official, qualified, or any other immunity, that there's an opportunity for a direct appeal. Walking in front of the courtroom, sometimes when the judge denies the claim of immunity, the party must wait till the trial is over before they can appeal that judge's decision. What we're asking for is a single bite at the apple that has to be done during a short period of time to where the municipality or other affected parties can appeal that judge's claim. Having worked for a consolidated government for over 30 years, having experienced many lawsuits involving law enforcement, qualified immunity, and other things, I can tell you that the cost of gathering discovery and the time involved in preparing for a case when you are denied immunity at the front and then at the end granted that immunity on appeal, you realize the cost, unnecessary cost to the taxpayers for gathering that. So it's very simple. I've worked with all parties to get this bill to where it needs to be. And I know there have been some friendly amendments offered up through the cooperation of ACCG, GMA, and I think GTLA and some other groups. So I'm absolutely open to those friendly amendments because I do think it makes the bill a better bill. And with that, I'll stand for any questions.
Thank you. Any questions? All right. We have. Let's see. All right, Representative Holcomb.
Thank you. How prevalent is this?
How prevalent?
Yes.
Well, I can't give you case prevalence. I would make an assumption that if with as many opportunities and I know there are people from GMA and ACCG here, but in my segment of the government, the lawsuits were all the time. And in many cases, whether it was Superior Court or federal court, the first action that was always taken by the consolidated government of Columbus was to file for the qualified immunity. And in the vast majority of those cases, we were granted it, whether it was qualified, sovereign, or whatever. The concern in this was those times when it was not granted until after the case, the appeal, it was not granted, and we had to wait until the case had concluded before we could appeal that. And I couldn't tell you how many numbers it happened. It happened several times in my career. But I think those more qualified to answer that particular question would be ACCG or GMA.
Okay. And they are signed up to speak.
Yes, sir. Yes, sir. It's a
Any
great
other
question.
Any other questions? Before we get into the witnesses, you mentioned sovereign immunity. House Bill 531 is a good bill over in the Senate that we worked a lot on.
Well, I think that's
so.
one we've all been talking about, and they're very excited about passing out of the
Awesome.
Senate.
Good deal.
I
Good
believe
deal.
that's the one.
Thanks for your work on this important
Yes,
subject.
sir.
So,
And anything carried by Chairperson Hong, we're really promoting those too. So.
all right. Okay. If there are no questions, no more questions for Majority Whip Robertson, we have some ACCG and GMA witnesses. Do y'all want to all testify, or Vivian Ernestes, who was recently the DeKalb County Attorney, is now at ACCG.
Good afternoon. Thank you for having me, Vivian Ernestes, ACCG. So I don't think I can say any more than Senator Robertson has said. He has eloquently presented the bill. I'd be glad ACCG and GMA support the bill and the amendments by the Georgia Trial Lawyers Association, and I'm glad to answer any questions you may have.
And we have Ryan
Ryan
Bowersox with GMA.
Just echo those statements. We're in full support of the bill and the amendments.
Okay. We have amendments 1 and 2, and I guess well, do y'all, how should we, do y'all want to talk about the amendments or wait until a motion's made, or what?
We can talk about
let's
the
go ahead and jump
amendments.
into it. Tell us
why
about
don't we
amendments
just tell you a little
1
bit
and
about
2.
the amendments so that you understand. The first amendment is to add in the reflection that this only applies to civil actions. It doesn't apply to any immunity claims in criminal actions. and specifies that it applies to both the granting of immunity and the denial of immunity. Technically, I think the granting of immunity would be a final appealable, directly appealable order because it ends the case, but this just makes it clear that it applies to both situations. The Second Amendment adds in and specifies the types of immunity. So sovereign immunity, as you know, is the county immunity or a city immunity. It's what we call an entity immunity. But then it specifies municipal, official, qualified, legislative, or judicial. Those are more the personal immunities and really apply in the situation that Senator Robertson has brought as the genesis of this bill, and that is when county or city employees are sued. And after the comma comes in their individual capacity. And so that is the immunity that we are trying to give one bite at the apple, one directly appealable shot at taking it up to the appellate courts. Those are the two amendments.
All right. Anything else from, any questions for GMA or ACCG? We have 2 additional witnesses for those, but does that cover it for ACCG and GMA?
Yes, sir.
All right, actually 3 from GMA, but we're good. Okay. All right. Anything else from any other witnesses on Senate Bill 298? I want to thank everybody for working together. This could have been a lengthy hearing, but I appreciate the efforts of trial lawyers and local governments and majority leader or majority whip for getting this cleaned up. So we have a bill. We have some proposed amendments if anybody moves for them. So what's the will of the committee?
Motion to pass.
Second.
We have a motion do pass. We have a second. Do we have any amendments?
Can we just offer those one, Mr. Chairman?
Sure, absolutely. All right, we have an amendments 1 and 2 in the revised language. We have a second. All right, any discussion on the bill as amended? I guess let's vote on the amendment. Okay. All in favor of the amendment, say aye. Aye. All opposed? All right. We have the bill as amended. Any discussion on that? All right. All in favor of the bill as amended, say aye. Aye. All opposed? All right. The bill passes as amended.
Thank you, Mr. Chairman. I appreciate you and committee members. Thank you all so much. Gullett is carrying the adoption bill, and Leverett is carrying the immunity bill. Thank you both. Thank them both so much.
All right. Senator Hodges, tell us about Senate Bill 245.
Thank you, Mr. Chairman, and thank you, House colleagues. It's a pleasure to visit with you today. I have Senate Bill 245. It is LCA 570150. Senate Bill 245 is Grandparents Visitation Bill. But before I tell you what the bill does, let me just say this up front. Georgia does and should defer to parental rights in matters of raising children. I honor that principle. Let me also tell you that this bill is not about custody. There's nothing in this bill about custody. This is a simple bill. It means a lot to grandparents and families. This bill simply allows grandparents who already have visitation rights granted by court to go back to court to modify those rights. Under current law allows parents, guardians, and legal custodians those rights, the right to go back and revisit a visitation order. And I'd like to point out that guardians and legal custodians may not even be blood kin. But it does not allow, current law does not allow grandparents to do this. Again, no change in the way we handle custody. This bill amends OCG 19-7-3 so as to include grandparents within a category category of who may seek to revoke or amend an existing grandparents' visitation order. They're included with parents, guardians, and legal custodians. As a lot of our bills are, this bill was brought on by a constituent issue of mine. Linda and Steve Smith, who are here today and will be glad to testify, had a grandchild by their son. Their son died, and for what the Smiths thought were the best interest of their grandchild, the Smiths wanted to petition the court to seek a change in their visitation rights. They found out that as grandparents they had no standing to petition to modify their rights established by an earlier order. They found 19.7.3 silent on this issue. As a matter of fact, they were referred to a case from Georgia Appeals Court in October of 23. It's the Namdar case. And the Namdar case found that under current law, grandparents who have previously been granted visitation rights have no right to file an action seeking to modify the existing visitation order under current law. As a matter of fact, Gary Graham is with me today. He is a family law expert, and Gary was the attorney in the Namdar case, so he'd be glad to speak too. This bill simply attempts correction by amending 19.7.3 and revising subsections C and D. Subsection C adds grandparent to the list of legal custodian, guardian, or parent as able to petition for revocation or amendment of existing visitation rights. It's line 38. Bill also, on line 64 to 68, adds after such visitation rights are granted to the parent of a deceased, incapacitated, or incarcerated parent, in other words, grandparents, such grandparent may petition the court for revocation or amendment of such visitation rights for good cause. I would just, in closing, I would just acknowledge again that Georgia law does, and Georgia law should, defer to parents of children about visitation rights. I don't think this this law endangers that principle. I don't believe it's right, and I don't know that it was meant for grandparents to just be shut out of the modification rights process under all circumstances. I would ask you to remember that a judge would hear the facts, and a judge would make the final determination. And I would ask you to remember that this bill does not change any of the standards by which a judge will rule. Mr. Chairman, I'll pause there. As you know, I am not an attorney. I do have Mr. Graham here with me, who probably could speak to legal questions better than I. And I have Mr. and Ms. Smith here who would like to speak to the situation. So,
Thank you, Senator Hodges. Thank you, Representative Townsend, for coming with Senator Hodges. Good to see you. Looks like we have a question from Floor Leader Sue Hong.
Thank you. Senator, good seeing you, my former floor leader, sweet mate. So I'm just trying to understand a little better because I don't practice in this area. So I think I'm going to start with actually line 64. So that section we're talking about, and so we're talking about if the person has custody and if a parent has custody and the grandparents have visitation rights already and the parent dies, then the grandparents can petition for continued visitation rights. Am I understanding that correctly?
And definitely, Attorney Graham, I think the Senator invited you to speak, so if you can shed a light on it, feel free to.
Okay, thank you. So the statute requires that parents be separated or that a parent is incarcerated or deceased. And in that case, the grandparents can seek an original action for visitation. But what this does is allows them also to seek a modification of their existing visitation.
See, go back to
Okay.
the Smiths, and the Smiths will speak to their situation, but the Smiths, again, had a son who had, they had a grandchild through their son, and the son died. The son died, and the Smiths believed it to be in the best interest of their grandchild, after the death of their son, to petition the court for a change, a modification in their visitation rights. The court said, we can't do that. The law will not allow us to do that.
That they had no standing to do
No
that
standing.
because they weren't a parent? Is that correct?
Well, because the strict construction of the statute in place now, the Court of Appeals found that the statute says what it says, and it doesn't include grandparents' right to modify, so sorry, grandparents.
Or we need
But
the,
it allows legal guardians or, you know.
the parent,
Yes.
yeah, or legal guardian can, but not grandparents.
Right, but as the senator alluded to, legal guardian may not necessarily be blood related, right?
Right.
So you're giving someone not blood related the right to modify, but you're not giving them grandparents the right to modify.
And then, if you can you elaborate the other part that we're fixing or changing?
Yeah, basically what you're fixing is on, I guess y'all do line.
Just line 30?
Yeah,
Uh-huh.
line 35. Okay? After visitation rights have been granted to any grandparents, it's adding such grandparent or the legal custodian, guardian, parent may petition for revocation or amendment of such visitation rights for a cause shown, which the courts may discretion may grant or deny. However, and this is an example of protecting the parental right to parent. However, these petitions should not be filed in any more than once in a 2-year period. That's one basic.
And that has nothing to do with the parent not being there, basically parent not having, the parent may be still there, but we're just allowing grandparents to be able to modify.
Yes, as long as the parents are separated or divorced.
Okay, thank you.
Any other questions? Representative Silcox.
Thank you. I was just curious, I mean, I feel badly for the Smiths, but I was just curious, what if there's an adverse relationship with the remaining parents, and the grandparents want to visit, but the mom or I guess the existing parent that did not die does not want that?
You can answer the legal part of that, but from a practical standpoint, remember that with the rights that this bill would give them to petition the court, they still have to go to a judge. They go to a judge, they say, we'd like to see our grandchild. We'd like to see our grandchild more than we've seen. And the parent has the right to show up and say, no, I don't think that's a good idea, and here's the reason. The judge would hear the arguments. The judge would make the final decision.
Okay.
And from a legal standpoint, line 18, which is the burden for grandparents to acquire visitation, and if this bill is passed, to modify visitation, again, is a direct result of a parent's right, constitutional right to parent, because you have one of the highest burdens in the law of clear and convincing evidence that the health or welfare of the child will be harmed unless such visitation is granted, and if the best interest of the child will be served by such visitation. And then the statute lists, you can consider harm if, the child resided with the family member, if the family member provided support, if there's an established pattern of regular visitation. So, in other words, the grandparents have to have some involvement, right? And unfortunately, that involvement may be frustrated as a result of parents divorcing or, God forbid, one of the parents passing.
Thank you. Representative Holcomb.
Thank you, Mr. Chairman. I remember when this came through, and I remember questioning whether it would survive constitutional scrutiny in light of Troxel versus Granville. And my recollection is that those on lines 38 and 39 that were given this authority were those who actually had the custody of the child and not a grandparent who would just be given visitation. So is it your sense that this would survive constitutional scrutiny if challenged?
Absolutely.
Why?
Because of the clear and convincing evidence standard. That's how you take into account Troxel and the parent's constitutional right to parent. You can't just, go by a very non-stringent standard, like in divorce cases. Parents' custody of the child is based on what's in the best interest of the children. That's an easy standard. Okay? Then you go all the way up to what the law requires now, clear and convincing evidence, and that survives the constitutional attack of Troxel and a parent's constitutional right to parent.
Okay. Has that ever been litigated in Georgia?
To a certain extent, I mean, the NAMDAR decision, the Court of Appeals decision, does allude to that and does say that as a result of a parent's right, constitutional right to parent, that we have to have this high standard of clear and convincing evidence and harm. And then if we get to there, it doesn't stop. We have to show best interest. But we've got to clear those two hurdles first of clear and convincing evidence of harm, which, again, addresses the constitutional right to parent.
Okay.
Any follow-up?
No, that's it for now.
All right. Representative Westbrook from Savannah, which this is a big week down there.
Yes, it is. Thank you, Mr. Chair. Thank you, Senator, for bringing it. I just want to make sure, as I read this doesn't in any way affect how a grandparent would initially file for the visitation.
That is correct.
This is entirely modification and revocation, although it's hard for me to see why a grandparent would initially file and then, can you speak to that? Do you see that?
I've never seen a grandparent's visitation rights be revoked
Right.
or revocated. I've seen them be beyond frustrated and interfered with, as was shown in the NAMDAR decision. But no, if grandparents make it, one, it doesn't change the original right to seek visitation of a grandchild. Okay?
Right.
Yeah,
I really just trying to make sure that this is really just modification. It doesn't do anything to that initial determination.
That is correct.
Okay, thank you.
Any other questions? All right, Floor Leader Sue Hall.
Just trying to understand this area of law a little better. How do grandparents get visitation rights in the first place? Are the parents still alive and grandparents do they have standing to petition for visitation rights in the first place?
Yes, they do. But they have to show clear and convincing evidence of harm.
Currently, not with this, but I'm saying right now, how do grandparents get visitation rights?
The only way they can is by file an original action for visitation. And then if they get an original action and court order with visitation, the current law does not allow them to seek a modification of that visitation, which is completely illogical because the burdens for acquiring original visitation versus a modification of visitation are the same. It's clear and convincing evidence.
So they're able to petition for visitation rights currently, but they can't petition to modify.
Absolutely correct.
And they can petition for visitation rights even when both parents are still alive, they're just separated.
Correct.
Yeah. Are there other family members that can petition for visitation rights other than grandparents?
Yes, and it's defined in statute,
Like can an uncle, aunt, can they modify?
No, they cannot.
Okay.
But again, this simply applies to this grandparent visitation statute.
Representative Kelly.
Thank you, Mr. Chairman. Help me just understand why there would be a need to modify.
I will happily answer that, and I will give you a brief overview of the NAMDARs, the grandparents were my clients. They had an established and loving relationship with their grandchildren before their son tragically passed away and suddenly passed away. Mom moved shortly thereafter to Cobb County, Georgia. They all resided together in New Mexico. Grandparents filed an original action under New Mexico law for visitation. They got visitation, and again, that was the original action that I referred to earlier. They got the visitation, However, mom was able to manipulate the broad and vague provisions of the visitation to the point where grandparents didn't have any contact with their granddaughter, Maya, and a very strained relationship with their other grandchild, Zaid. And in fact, the trial court in the final order found that the vague and subjective language of the order has made it difficult, if not impossible, to conduct visits that could truly maintain the strong relationship the New Mexico court found to exist. Maya no longer visits with grandparents at all. A number of the visits with Zaid were limited by arbitrary safety restrictions, which in effect impacted the relationship between Zaid and his grandparents. The evidence is clear that without a certain degree of modification, the intent of the original visitation cannot be followed. And so, if you have a parent, you already have a visitation schedule in place, and you have a parent doing, engaging in actions such as that, the only remedy is to file for a modification to address. And the trial court did modify the visitation with respect to Zaid to give the grandparents considerably more time. Another example, and this is in the trial court's ruling, the trial judge and the guardian ad litem for the children specifically found that mom has engaged in alienating behaviors to the kids against the grandparents. Such as talking negative about the grandparents, frustrating the original visitation action. And so we got that far, all for naught, when the Court of Appeals employed their strict construction and said, sorry, but grandparents don't have a right to modify. And so now my grandparents, the Nandar grandparents, they're just sitting in no man's land. They have no relationship with Maya. Zaid's relationship is strained, all because the law does not give them the right to modify their visitation that they originally acquired.
And help me out, I do zero family law. So I'm just now trying to walk through the fact scenario of the Namdars. Ex-husband, ex-wife, both lived in New Mexico. Grandparents lived in New Mexico.
No, husband and wife lived in New Mexico. Husband dies.
Okay. Wife moves to
Cobb
County. And grandparents in New Mexico filed trial court action in New Mexico. Correct. Did they already have a visitation provision in place?
No, they had to file the action to get an original visitation order in place. So they filed that action in New Mexico. The New Mexico order was, as the trial court found, very vague and subjective and open to interpretation that allowed mom to completely frustrate the visitation that was established by New Mexico. And so, okay.
No, you can go on. I'm just trying to walk my head all through. So moves to Georgia with the children. Grandparents are still in New Mexico. What did their visitation order look like in New Mexico?
Their visitation in New Mexico was supervised, which the grandparents agreed to because of false allegations by mom that they would do something to the children. In-person Skype visits. Visitation from 9 to 6 on July 1, 2, and 3, June 27th, 28th, 29th, December 27th, 28th, 29th, for the 2 days, the weekend preceding Columbus Day, and for 2 days, the weekend preceding President's Day. That was the gist of their visitation. And, example of the manipulation, there was a provision that, the visitation has to feel and occur to be safe by mom. So, for example, when COVID came out, no, you're not seeing your grandkids, even though we can socially distance and follow the CDC guidelines and all that. And so, does that answer your question?
Kind of. So then let me just keep walking through the procedure. So then they filed for a modification in Georgia.
Yes.
Was the original visitation action entered into when everybody was in New Mexico, or had she already moved to Cobb?
The original visitation action was in place when she moved to Cobb.
Okay, but she left New Mexico to come to Cobb.
Yes, sir.
But everything was done, and then the modification was filed here because now she's in Cobb.
Right, we filed the modification in Cobb.
And what was the modification asking for?
asking for increased time with the grandchildren to address the alienating behaviors that the trial court and Garnet Latham found that mom engaged in. You know, there's only so many ways you can address alienation, one of which is more time with that parent or grandparent who's being alienated against. And so after 2 years of litigation, a 5-day final trial, where the trial judge did modify the visitation with respect to Zaid, but also in the order says the alienation as to Maya is complete. She is totally alienated from her grandparents. So the court did nothing with Maya based on the alienation through no fault of their own, occurring by mom. And 2 years of litigation, 5-day trial, Court of Appeals, filing a cert to the Supreme Court after the Court of Appeals ruled. It's been a long battle.
What is, final question, Mr. Chairman, what is the burden of proof on the grandparent to establish visitation rights, and what is the burden of proof required to modify under this bill?
They are both the same, which is clear and convincing evidence that the health or welfare of the child would be harmed, and that's line 19, unless such visitation is granted and that the best interest of the child would be served by such visitation. So that's what I said earlier. It makes no sense to give grandparents the right to seek an original action for visitation when they have to succeed with the clear and convincing evidence standard, but not give them the right to modify that, especially in tragic cases such as Namdar, but the burden's still the same. In order to modify, you still have to do the same clear and convincing evidence burden.
Okay.
Any follow-ups? Chairman Smith.
Thank you. I've got a baby boy that's going to be 6 weeks old tomorrow. And both sets of his maternal grandparents live out of town. And so I understand that, I would love for them to see him if, heaven forbid something happened to my better half. But I'm just having a hard time wrapping my head around. I understand with what limited family law practice I was involved with, I can understand a parent modifying custody. But, I'm just sitting here with a scenario. We're trying to help the good grandparents like the Smiths. I love y'all's last name, by the way. I'm with you on the good grandparents. What I'm worried about are the bad grandparents. I've got great in-laws, love them to death. I'm trying to wrap my head around here. I mean, modification for a parent to, for their children that they help bear and raise. It's a lot different with a grandparent, though.
Right, and that's why the standard for a parent to modify visitation or custody of their own child is completely different than the standard for grandparents to obtain original visitation and a modification of that visitation. For example, in order to modify parental custody, you have to show a material change in circumstances or conditions since the last court order to the present to justify some type of modification. And with grandparents, to use your term, bad grandparents, that's why you have the high standard too. That's why you have to go through the trial judge. If the trial judge finds that we got bad grandparents here, then that's what's going to happen.
Yeah. I mean, no offense to my father-in-law, he's a Florida Gator, so I don't want to subject my son to much of that. But thank you for answering that.
Sure. And Mr. Graham, let me throw in there, Georgia has the Uniform Child Custody Jurisdiction version of that. So in terms of state lines, there are some laws in Georgia that govern both parents and grandparents, right?
Yes, and that's, the UCCJEA is how we're able to file here in Georgia. And why New Mexico, once mom and the kids moved, they entered the order, but then they said, she's moved to Georgia, so therefore we need to transfer it to Georgia. And that's all per the UCCJEA.
Before Federal Judge Jones was writing 500-page redistricting decisions, I saw him do that in law school at Georgia. That's been on the books for decades, right? A lot of law on that.
Yes.
All right. Follow up earlier on.
Thank you. And thank you for answering all these questions. I mean, I think
Sure,
a
I'm
lot
used
of
to it.
us don't practice in this area, so I really appreciate your insight. And I think I'm having, this kind of similar concerns that Chairman Smith had, but we went through that scenario where, the Smiths went through. What's a scenario when both parents are still alive, separated, and a set of grandparents have visitation rights and they want to modify? What's a scenario where they would want to modify? And my concern essentially is, I don't want grandparents to start having more of a right than the parent in certain scenarios. And, if we have both set of parents and grandparents have visitation rights, which I didn't know that happened, and they want to modify to have more visitation rights or more whatever, and modify, where both parents say, no, this is my kid, I don't want them to see my father a lot. So what's a scenario where they would be modifying?
Just like the Smiths, right? There's alienation, just like the Namdars, there's alienation that completely frustrates, without any legitimate basis, the grandparents' visitation with the kids. And there's other not as extreme examples, maybe, there's been a change of the family circumstances that would justify modification of grandparent visitation. Maybe the grandparents, aren't acting appropriately, and therefore you need a modification of visitation. Conversely, like I've harped on now, if the parent isn't acting appropriately, then the grandparents need to have a right to modify. And so we're not talking about, I want to stress, we're not talking about custody. Okay?
Right.
We're just talking about a visitation schedule, okay? That is, and to your point of you're just worried giving grandparents more of a right than the parent, clear and convincing evidence. It always goes back to that. And one, we're not talking about custody, we're talking about visitation, modifying visitation, under one of the highest burdens in the law.
Any other questions from the committee? All right, thank you so much. We have several people signed up. Let's start. It looks like we have two couples. I'm putting two and two together here. So the Smiths, would y'all like to testify together or separately?
Together.
Y'all want to come on up? Okay, thanks. Steve and Linda Smith.
Y'all sit here.
We're gonna get it figured out, sorry. This is his paper.
Good afternoon. I'm Steve Smith, and this is my wife, Linda. We're retired educators from the state of Georgia with a combined 72 years of experience together. So we love children. We enjoyed our careers, and we love our granddaughter. And we had to petition the court when our son and daughter-in-law separated. She initially refused to allow visitation with us or our son. We had to pursue grandparents' rights through the courts, and we did. And we were awarded grandparents' rights, I think, on January the 15th of 2015. And the grandparent rights that we had were we saw our granddaughter every fifth weekend throughout the year. That's at 4 times a year and 1 week in the summer. And we have never failed to honor our visitation in that length of time. And it's been fine. To answer some of the questions that you were asking, I think, is that the difference is now is that our son passed away last August, when they both of them shared custody, and at different times different ones had primary custody. You know, the mother had it for a while, the dad had it for a while, but even when it was shared, we were able to visit with our granddaughter pretty much every other weekend. So we had that ability to establish a really good relationship with our granddaughter. I mean, she loves us, we love her. We're not trying to take anything away from the mother at all. But our son has passed away, and right now, even to get the court-ordered grandparent rights, we have to engage an attorney every time it comes up, because our daughter-in-law says we no longer have grandparent rights. But the court gave them to us, and only the court can remove them from us. So all we're asking from y'all is to approve Senate Bill 245, because we feel like we're being discriminated against because we already have grandparent rights. And it shouldn't be that way. We're not asking for custody. I think she needs to stay with her mother, but we're asking for additional visitation so that we can maintain the relationship that we currently have with our granddaughter. Now, Linda can do a better job than I can about explaining things.
Thank you, first of all, for allowing us to testify in front of you. And I just want to address, I couldn't see because of the column, but someone was asking a question about what if mom and dad both refused. I thought that the bill was only for death, incarceration, or incapacitation. I might be mistaken on that because I'm sure not a lawyer. I was a second grade teacher, so excuse me if I'm nervous. But on August 10th, our son died of a massive heart attack, and I did CPR while, okay, all right, let's start over. We have a great relationship with our granddaughter, and it was one of his weekends, and I picked her up, and we were at the house, and he died of a massive heart attack, and I was trying to do CPR while she's calling 911 and goes outside to look for the ambulance, and he died at the house. And my brother came and took our granddaughter to her home, and our granddaughter was not allowed to attend the funeral of our son, as well as she was not allowed to attend the celebration of life. And her teachers and friends had come to support her because we had been through a horrific event together. Steve was at home. He had had back surgeries, which is why I was just with her. And when our first court-appointed visitation happened, it was about it was August 31st, and our ex-daughter-in-law did not show up, and that was when we had been instructed to call the non-emergency police, and they went to her, and she told us via text as well as the police that we no longer had grandparents' rights. They had died when our son died. And that was when we engaged a lawyer, and he had to contact her lawyer during the divorce of our son and his ex-wife, and we were able to see her for 2 times, and then again we missed her birthday. We weren't even allowed to call and tell her happy birthday or Merry Christmas. And when we were scheduled again to see her in January, and again, our ex-daughter-in-law was interpreting the law the way she chose to interpret it and said we wouldn't see her till May. And again, the lawyer had to intervene to just get the visitation that we had already been granted. And during the time our son had custody of Riley, we saw her many times. And seeing the 4 weekends plus the week in the summer was just an extra bonus for us to have a very close relationship with her. And when the lawyer explained that we had no opportunity to modify this in any way because of the current law, that is why we met with Mike to ask him to help us address, and Mike and Rick, help us address this situation. And we feel like that when a parent dies, a child shouldn't lose half of their family and not be able to talk to them or communicate with them. A child needs their grandparents. Grandparents are are very important in a child's life for lots of love and support. So we are imploring you to pass this bill to allow your fellow colleagues in the House to make the decision on whether this bill is worthy or not. And then for us, it means, again, none of this means we would be able to amend it. We would have to go before the court, just like we did last time. Somebody was asking the guardian ad litem visited our house. There were multiple things we had to go through, and there's been despicable things that have been done that I'm not going to say they would be addressed in a courtroom, not here. But it is all up to a judge to decide this. It's not up to us. We just present the case. So we're just asking, pleading with you to give us that opportunity.
And the judge in the case back in 2015, she said it usually takes me 6 weeks to make a decision in these cases. But it's not going to take 6 weeks, 6 days, or 6 minutes. I'm making my decision right now. The Smiths have grandparent rights. And then we didn't know what they were at that time, but she prescribed what they were, and we were happy with it.
Mr. and Ms. Smith, thanks for coming up from the
Thank
coast
you.
to testify. The O'Briens look like you're together. Would y'all like to testify together? Mr. and Ms. O'Brien.
Can I testify with my parents? I'm Shelley Namdar.
Now I have, okay, sure, come on up, y'all testify together.
Thank you for the opportunity to speak today.
Thank you, and if you'll just introduce yourselves.
My name is Jane O'Brien.
Okay,
I'm Shelley Namdar.
okay,
And I'm Richard O'Brien.
thank you. Okay, please proceed.
I am a parent and a grandparent. I want to share with you my opposition to SB 245. Grandparent visitation laws across the country are highly controversial because of the potential for violating constitutional law. The 14th Amendment gives parents the right to make decisions for their children, the right to care, for the care and custody of their children, a right upheld by the U.S. Supreme Court. On the other hand, grandparents have no legal right to make decisions regarding their grandchildren and have no legal responsibilities to support them. When grandparent visitation cases are heard by a court, the judge is asked to consider overriding a fit parent's right to make decisions regarding contact between them and replacing the parent's decision-making with the judge's opinion. This is a solemn responsibility because a parent's constitutional rights are at risk in every court action that's taken. The Georgia Grandparent Visitation Statute bases its constitutionality on requiring the children be at the center of the decision-making. In other words, by clear and convincing evidence, the health or welfare of the child would be harmed unless the visitation is granted, and the best interests of the child would be served by such visitation. These factors are what allows a judge to consider overriding a parent's constitutional right to the care and custody of their children and granting visitation to grandparents over the objection of a fit parent. Currently in Georgia, if a grandparent meets specific criteria and visitation is awarded, the statute provides a minimum amount, 24 hours a month. A truly substantial amount of visitation considering the constitutional issues, and a very generous provision of other state statutes. I'm asking you to please consider the very real possibility that the authors of the current Georgia statute, that's been in effect for years, provided for this very generous 24-hour-a-month visitation and intentionally excluded the grandparents from unilaterally requesting more visitation. In other words, prevented them from returning to the well. I believe the exclusion of grandparents in the modification provision in the current statute was not an oversight. Instead, exclusion of the grandparents was very intentional, and I urge you to strongly consider this argument when deliberating on this bill. While I object to the passage of SB 245 in total, I also object to the specific language it contains. SB 245 proposes in C2 and D1 that a grandparent may petition for modification for good cause. The term good cause is appropriate in describing modifications requested by a parent, by a fit parent, to address the needs of their children. The term good cause, when applied to modifications requested by a grandparent, is wholly inadequate. It fails to provide the specific guidelines for court deliberations that are required to protect the constitutional rights of the parent. Therefore, I ask you to consider that the term good cause is extremely subjective and not nearly complete enough to be considered constitutional when applied to a grandparent requesting modification. To summarize, I oppose SB 245 in total and in language. First, I believe grandparents were purposefully excluded from the ability to request modification because the Georgia statute sets a very generous minimum visitation amount, and because continuing litigation presents a further threat to the constitutional rights of a parent. Second, I am opposed to the language. I believe allowing grandparents to request modification for good cause is unconstitutional. I want to share with you what the Georgia Supreme Court and Georgia Appeals Court have written regarding grandparent visitation. The Georgia Supreme Court has written the following: the right to the custody and control of one's child is a fiercely guarded right in our society and in our law. It is a right that should be infringed upon only under the most compelling circumstances. The Georgia Appellate Court has also written the following: accordingly, the Georgia Supreme Court has held that to pass constitutional muster, statutes that allow a court to grant a grandparent visitation rights over the objection of a fit parent must require a showing by clear and convincing evidence that the health or welfare of the child would be harmed unless such visitation is granted, and that the best interest of the child would be served. I do not believe SB 245 meets the constitutional standard described here, and I am asking you to reject the measure in its entirety.
Representative Kelly.
Thank you, Mr. Chairman. I was just asked the Court of Appeals and the Supreme Court cases that you just quoted from. Do you happen to have the sites so that maybe we could do some research on those?
Yeah, I have, and we'll give you more information on that in the final person to go. The first one was Suggs, 249. And the other one was Patton, 304.
All right, can you say that again one more time?
Suggs, S-U-G-G-S, 249.
And that was a Supreme Court case?
Yes. And the other was the Georgia Appellate Court, Patton, 304. And we will provide you with more information on it.
Okay, thank you.
Any other questions for Mrs. O'Brien? All right, Ms. Namdar.
Hi, good afternoon. I am Shelley Namdar, and as previously mentioned, I was part of the 2023 Supreme Court decision. Actually, it was the Appellate Court decision in 2023. I obviously have firsthand experience with this as a parent and what modification filings can do to the family with the children. So I'm very grateful that you guys are providing the opportunity for me to share my experience with you and why I strongly oppose SB 245. First, I want to provide you the timeline of my involvement in grandparent visitation and then the impact. In 2016, my husband died, leaving me and my two children aged 5 and 7 without a husband and a father. We lived in New Mexico at the time in the same city as the paternal grandparents. The relationship between our two families had been strained for some time. A healthy relationship would have been ideal, but it only seemed to become worse after his death. My husband's parents filed against me for grandparent visitation within 5 months of my husband's death, despite the fact that my children and I had both been visiting with them on a weekly basis. After 18 months of grueling litigation and a full-day hearing, the judge granted the grandparents' visitation per the New Mexico statute. The grandparents voiced their opposition to the ruling, but they didn't file an appeal. The New Mexico order worked well for my family. It was written in a way that allowed visitation that suited the children as individuals, and it also sought to protect my rights as a fit parent. Because my children and I had relocated, our original order from New Mexico was transferred to Georgia's jurisdiction. Only 11 months after the date of our New Mexico order entry, the grandparents filed an action against me here in Georgia and very quickly requested a modification of their grandparent visitation order from New Mexico, even though the current Georgia statute does not allow grandparents to initiate a modification action. Although the judge was informed the statute did not allow this action and I was not in favor of modification, he unfortunately agreed with the grandparents' request and the case moved forward. The litigation for this grandparent-initiated modification drug on for over 3 years and resulted in a 5.5-day court hearing. What followed was an order that substantially changed visitation for my children over my objections and violated my constitutional rights as a parent. The Georgia Supreme Court has written the following, that to pass constitutional muster, statutes that allow a court to grant a grandparent visitation rights over the objection of a fit parent must require a showing by clear and convincing evidence that the health or welfare of the child would be harmed unless such visitation is granted, and that the best interest of the child would be served by such visitation, and that it must be under the most compelling circumstances. In my case, no compelling circumstances were provided to request modification, and the burden of harm was not met for the changes that were made. I filed an appeal to the Georgia Appeals Court, and the grandparents counter-appealed because they still were not satisfied with the judgment they received. Eventually, the appeals court ruled the lower court judge had erred because grandparent-initiated modification is not permitted by the Georgia statute. Our modified visitation ruling was thrown out. The grandparents filed a petition for certiorari to the Georgia Supreme Court, which was later denied by all justices. The appeals and Supreme Court activity lasted for more than a year. Now for the impact of being sued for grandparent visitation. It is true, when one person in a household is sued, it affects everyone in the household. These court actions were emotionally and financially devastating for me and my children. I spent over 6 years in litigation in an 8-year period, during the time my children were in their formative years. For me, every day was filled with dread and worry for bad outcomes and the continued integrity of my family, afraid what the frequent filings would hold, and distracted by frequent meetings, phone calls, and paperwork. The financial burden of being sued for grandparent visitation is extremely important to consider. The cost for me for grandparent visitation-related charges in New Mexico for the original order was over $100,000. The case-related costs to me for the grandparent-initiated modification here in Georgia that was subsequently thrown out was over $150,000. My husband left an insurance policy for us, $250,000. It's all gone toward the grandparent visitation court cases. I know that I've tried to deal with this while trying to support and raise my 2 children to the best of my ability, but I know that they have ultimately suffered because of the experiences that I've had to endure. One more important impact. My rights were violated in various ways during the litigation here in Georgia. I will share with you just one example to illustrate what happened to me during this case. The Superior Court judge awarded a 2-week summer visit to the grandparents in which they could take my son anywhere in the continental U.S., and they only needed to provide me a general location of where that visit would take place. My son has moderate autism, ADHD, and epilepsy, and has never spent anywhere close to that time under the care of the grandparents. Despite my objections, the judge granted the grandparents' request and ordered the visit. My constitutional right as a fit parent for the care and custody of my children was violated when the grandparents flew my son to New Mexico on that 2-week visit in 2023, despite my objections being made to both them and the judge. What I've just described to you is what happened to me because of a grandparent-initiated modification case. This is the exact provision you would be voting to add to the statute if you were to approve this bill. Allowing a grandparent to request modification every 2 years is about the desires of the grandparent and not about the needs of the children. On behalf of myself and all other families that are headed by fit parents that don't deserve to spend the majority of their young children's lives in court, family court, I appeal to you to please reject SB 245.
Thank you. Any questions? All right. We do have Representative Westbrook.
Thank you so much for being with us. I'm just trying to make sure that I understand your position, because it sounds like your position is that you don't think grandparents should have visitation. Is that right?
I don't think that they should have the ability to come back and modify once they've established visitation.
Okay.
Now, ultimately, I believe that if a grandparent wants to have a relationship with their grandchild, they first should and foremost should focus on building a healthy relationship with the parent, which is not something that happened in my case.
Okay. Yeah, I definitely understand that. I think our challenge is, making a decision that will apply across a broad set of factual scenarios. So I just wanted to make sure, because it's, the right to file an action to ask for grandparent visitation already exists.
Right.
So all this does is just alter that so that folks can modify. But from what you're telling me, you're okay with the law as it currently stands. It's just the modification piece of it that you object to?
There are a lot of constitutionalities to the law itself. Just being in the system for as long as I've been, New Mexico, for example, that's where we've got our original order. They did I will say that they did a great job regarding the parents' rights. That if I felt like, the judge said, okay, your son is disabled, it would be a good idea to have the visits be supervised, because grandparents have trouble keeping up after a child who has autism and ADHD at the time. He wasn't even diagnosed with epilepsy at that point. But she believed that there needed to be some safeguards because I was the parent and I was requesting that they be in place. So they did a great job there. Now, as far as I can tell you that in practice, when they say clear and convincing evidence and that they have to prove harm, in my case, there wasn't any of that proven. And in fact, my attorney moved when they rested their case, when the opposition rested their case, my attorney moved for a directed verdict because they had not met the burden of proof yet. But the judge, even though they had not, he said he wanted to go ahead and proceed. So I can't say for sure. I mean, I know in my case that the burdens weren't met the way that they say that these high bars are set, but it's not. It's always up to the judge's discretion.
Thank you.
Yeah.
Any other questions? All right, Mr. O'Brien.
Okay, good afternoon, everyone, and Mr. Chairman and committee members. I appreciate you giving us all this time, and I apologize if my voice goes out, but I've had some pretty serious health issues.
Just move that mic around.
Okay. So, I have some prepared thoughts that I wanted to really dwell on, but I would be remiss if I didn't point out to this committee that the description of the Namdar case, as presented to you, is a misrepresentation. It is, in my opinion, it is fraught with misinformation.
We hear you on a disagreement with the other side in this family
Right.
case, so
Right.
please proceed with the other things.
So,
Since
all right. So, you've heard my wife and daughter present reasons that we feel that this committee should vote against SB 245 and the constitutional issues, the personal experience my daughter had with the grandparent-initiated modification, and more importantly to me is I saw how it affected my grandchildren. They did not get what they deserved as far as having a parent as an integral part of their lives, because Shelley spent an inordinate amount of time, and I'm not talking just a few hours here and there. There were long periods where the demands for information and answers and justification took all-nighters many times over. This is a single mom with a handicapped child, a special needs child. And if you can't put yourself in that position, it's extremely difficult. And what else wasn't mentioned was Shelley moved here because she wanted to be near her family unit. Because after she was married and moved off and had her children, we may have gotten to see them once a year, but they lived away. But I can tell you, I never, ever thought about pursuing some legal action to get access to my grandchildren. Another thing that I'd like you to consider is that every court encounter further damages the relationship between the parent and the grandparent, which unavoidably affects the kids. And they are at the core of all of this. And that's what I think is being forgotten. A grandparent visitation lawsuit places a parent in a family court system that typically is more in tune with two good, or two parents, and they're talking about custody issues, they're talking about property, things like that. And I don't think at this point the courts are fully equipped to be able to handle visitation, because many of the decisions that were made on an equal basis. Grandparents and parent were co-equals. And I don't believe that to be true. And an example of that, there was a court-appointed guardian ad litem. Now, guardian ad litem, in my opinion, and from everything I've read and spoken with her lawyer, Shelley's lawyer, was that they're there to make sure that the children are safe, they're in a safe environment, they are not being abused, they're healthy. I can tell you, the whole time this guardian ad litem was assigned, she never met with either child. But yet recommendations were made to the court, just gut feel, and what the grandparents had informed her. So she got one side. And my point there is, this is not a fair system to open up. The penalties are borne by the parent and the grandchildren. And I might also add, what grandparent would sue for visitation when they already had it and deplete the only money that their son's spouse and their grandchildren have for college, for anything? Shelley's very fortunate we were here. We filled in a lot. But if we weren't, I often think, what would have happened to the children? The GAL, like I said, never, ever interacted with the kids. One day, Shelley approached the GAL and said, "What about my constitutional rights?" And the GAL said, "This is grandparent visitation." "What do you mean, constitutional rights?" She goes, "I don't know what you're talking about." Now, that information was fed back to the Superior Court judge for him to make a decision on visitation, which was not authorized by the statute to begin with. So you can see this is just a bad situation going from bad to extremely bad. We talked about during this entire interaction, it became even more adversarial because there were things said in the courtroom that are, I can't say it any other way, they were just bald-faced lies. So, to me, it was a system of false allegations, or where false allegations in that courtroom were rewarded in this case. And the truth was sacrificed. So, without getting into specifics, somebody on the grandparent side provided the court-appointed forensic psychologist, as well as the guardian ad litem, with a portfolio of allegations against Shelley. Drug addict, child abuser, everything else. Unbeknownst to her, never able to put the facts out there and defend herself. And I mean, I'm sorry, but this is underhanded stuff. These are the bad things that can happen. There are good things that can come out of this whenever the parent is really rotten and tries to keep the grandparent from having any access to their grandchildren. But when the parent has offered and given access to the kids weekly and then they turn around and sue? I don't understand. And that's what this bill will do. It will give them all kinds of opportunity to come back every 2 years, take another bite of the apple, and everybody talks about good cause, and it's going to meet a high standard, that it's in the best interest of the kids, etc. I agree with that, but you can't get there unless you go to court. And when you've already exhausted every penny that a parent has, and now you come in and you decide you're going to take them back to court, what happens when you have no money? By default, you lose. You lose. And just as an example, think about a kid that's 2 years old, or children that are 2 years old, and the grandparents are given visitation, and they want to come back every 2 years. There could be 7 court cases. Think of the burden that puts on the parent and the burden it puts on the kids. Oh, by the way, these children that were supposed to have been abused, they were both on the honor roll. Nobody thought to ask that. I can tell you right now, we're based on the presence of some individuals here, we know where this bill was initiated, this modification. I can tell you right now, without a doubt, as soon as this bill, if it gets through this committee and goes to the floor and is passed, I can guarantee you within days, Shelley will have another summons that she'll be served with, and she'll be back in court again. For how long? Every 2 years at least.
Thank you, Mr. O'Brien. Anything to add? Looks like we have a question for Mr. O'Brien from Representative Holcomb.
Or for Shelley. How old are your kids now?
My son is 14 and my daughter is 16.
Okay.
When this started, they were 5 and 7.
Okay. Thank you.
Any other questions? All right. I would imagine the proponents of the bill are going to have some response to some of the things that were mentioned. And Joel Wiggins was here to testify. He got called across the street to another meeting. He's knowledgeable on the subject. I have seen a lot of questions from committee members. I know this is an important subject.
Yes.
Senator Hodges, I know it's important to you. Representative Townsend, I know it's important to you. Representative Townsend, do you have something to
Yeah, I didn't know if you
say?
want to make a couple comments real quick. It's up to you, or I can wait.
Why don't we do this? I think in light of what we've heard today, we welcome emails and supplements in writing to email addresses of the committee. I'm going to talk to Chairman Gunner about placing this on the calendar tomorrow, along with the other bills that were scheduled to be heard tomorrow. We will be meeting again tomorrow. So we will take this meeting, which has been very informative, as a hearing only today, and we will take action at a future date and welcome further input on this important family law subject.
If I can just say one more thing, that all of the references that we gave to the appeals court and the Supreme Court, they're all in
My case.
her case. So it would be very helpful
For the
probably
Namdar,
if
be
you would
Namdar
read
case.
the appeals court decision.
We've got it. We've got it. We've got it. I guess since you had an addition, Representative Townsend, if you have something brief, and definitely you're welcome to speak to the committee.
No, I'm sorry. Yeah, just real quick, I was going to say, and I can talk more later. So now this was, for us, a constituent-based issue, and where it came from was the first phone call I received. I included Senator Hodges after that about what happened, and basically about the petition rights. And that's where this goes. This is definitely not custodial rights, petition rights, and I think this is something we can clear up and allow the courts to decide, the judges, and help the judge decide. That's all we're asking. That's it. I appreciate your due diligence in running the committee.
Thanks for your leadership on this and other issues. Thank you for everything that's been presented. We welcome more information, and we will take action at a later date. Thank you. I believe that wraps up this meeting.